Fani Willis and her prosecutors in Georgia now admit that they colluded with the White House counsel. We're going to go through this hearing, which took place in Scott McAfee's courtroom. The judge was listening to arguments related to Jeffrey Clark, a co-defendant in the RICO case, and he is saying, we want motions to compel the government. Fani Willis and Nathan Wade, you see him there walking into the courtroom with his water bottle sitting down. No Fani around him, but saying that they have information that they need to give over to the defense, that they need to see it. One of those items are apparently letters from the White House counsel. And you might be saying, well, Rob, aren't they communicating with the feds? Well, maybe they were communicating with the January 6th committee, which would be a problem in and of itself because they're supposed to be doing their investigation on their own. They're not supposed to be copying and pasting Liz Cheney's homework, but we know Nathan Wade doesn't have a good history of taking notes or doing his due diligence, so he probably did just take her homework and just copied it. But the point is, they're not supposed to be doing that. It's supposed to be an independent investigation from Georgia with their grand jury and all the things. But why would they also be talking to the White House counsel? That's Joe Biden's office. That's the White House. That's a political entity. Why are they getting letters from them? Well, let's see if we can break it down. This is the hearing that took place out of Scott McAfee's courtroom. Took place on a Friday. Now, the first part of this hearing includes a conversation about another issue. And so we're jumping into this kind of after the first issue has already been dealt with. And the judge is going to carry this over into this argument about whether Fani's office should be compelled to disclose information to the defense. And so this guy up at the bench right here is the lawyer for the defense. You can see here, this is the prosecutor's table, which we're going to hear from another prosecutor who is not Nathan Wade, who's going to speak and offer the government's perspective. But we'll break this down as we go. Scott McAfee is wondering what's going on with the communication between Fani's office and the White House.
All right, so let's talk about your part two, White House communications.
Right. So we know that there were contacts between the White House and the prosecution team because Mr. Wade's billing records that were filed into the Mike Roman motions show a conference of White House counsel on May 22nd of 22 and another conference at the White House, I believe, in November 18th of 22.
Okay, now these are records from Nathan Wade's bills, right? We saw this in the Roman motion. We had not heard yet about the actual communications that have landed in Fulton County's office. So up until this point, this has been largely speculative. Like the defense has been saying, well, we've seen the billing entry. We don't know exactly what that means. We don't know if that was a meeting about whatever it was. Now they're going to say eventually that they actually sent letters over to Fani's office. So he's describing just the billing records, and then they're going to reveal more information to us.
Which brackets more or less the work of the special purpose grand jury. They were impaneled on May 2nd of 22, and I think they heard their last testimony right around that November timeframe. The reason that matters, Your Honor, is the obvious political dimensions of the case. The DA was already disqualified from investigating or prosecuting Burt Jones because of a political conflict of interest, because she was campaigning for his Democrat opponent using the imprimatur of her office. So the DA's politics were already in this case on a de jure basis long before the indictment was even issued. The White House has its fingerprints on all four criminal prosecutions of President Trump, and now we know they have their fingerprints on this case.
Okay, so he gave us interesting conversation jumping off point about this case. So he said that Fani has already been disqualified. In a prior case back in 2022, a judge blocked Fani, seen here, from developing a case against a Republican state senator. It was already blocked on this. A Georgia judge on Monday blocked Fani from investigating Burt Jones. Jones is one of the 16 fake electors who's been charged. Jones is currently running for lieutenant governor against Democrat Charlie Bailey. Fani campaigned and hosted a campaign fundraiser for Bailey, and she donated to him. So she supports this guy called Charlie Bailey. Charlie Bailey is running against this other guy, Jones, and Burt Jones has now been indicted by Fani. Isn't that convenient? Yeah, hey, Charlie Bailey, this is Fani Willis talking. I'd love to host a fundraiser for you. Yeah, campaign fundraiser. How's the campaign going? He's like, well, it should be going good. It could use some more money. But also my opponent's a pain in the butt. Yeah, his name's Burt, and he's driving me crazy. And she says, oh, guess what? I'm the DA. How about I just indict him for you? So in his ruling, a Fulton County Superior Court called Judge McBurney, he said Willis's office may ask witnesses about the senator's role. What her office may not do is make sure any such evidence and develop against the senator. Saying last week, McBurney criticized Willis for hosting a fundraiser, said the optics are horrific. That was a long time ago. Talk about these optics. I wonder what this judge thinks about these current optics. The Prosecuting Attorneys Council of Georgia can select a replacement district attorney, and that person can question Jones, but she's been disqualified from that. So Fani's obviously very political no matter what she does.
President Biden is reported to have complained that the Department of Justice was taking too long with the case against President Trump.
That's right.
And he said at the White House on November the 9th of 2022 that he would pursue every constitutional means
Joe Biden
of stopping President Trump from taking power.
That's right.
And that was 9 days before the November 18th meeting at the White House reflected on Mr. Wade's bills.
Interesting.
The criminal cases against President Trump are being pushed to have their trials before or during the election. The DA in this case is pushing to have this case start in August. And according to their time budget, that means that it would be tried while voting was occurring. A reasonable person might view the whole picture as having a political purpose. And in fact, a lot of people in this country view it that way according to opinion polls. And certainly most Republicans view it that way, assuming they're still entitled to have opinions.
Not really.
So those communications with the White House are relevant to a potential selective prosecution or due process defense in this case. And as for Mr. Clark, one reason we are a little suspicious about politics, we cannot find any other cases where a lawyer or anybody else, for that matter, was prosecuted over a draft letter that was never sent.
Talking about Jeffrey Clark.
Under a theory of attempted false writing or attempted false statement.
Draft
I haven't
letter.
found a case where that happened in Georgia nor anywhere else.
Of course
Maybe
you
it's
haven't.
out there, but I haven't found it yet.
No, of course not. Because
So that alone, when you can't explain it, when it doesn't make any sense, there must be some other reason. It is reasonable to infer that it's politics. So we're asking the court to order them to produce those documents in addition to the two-week correspondence. Now, I expect what we're going to hear is what we heard on President Trump's motion, that there aren't any documents, but they haven't said that yet, so they get a chance.
Okay, so do you see where this is going? I gave away the surprise ending. Okay, they admit that they've got docs, but this defense lawyer right now is like, well, they don't have anything. They say they don't have anything. We just got the billing entries and hope, but we need to look into it.
Chance to come up and respond to that.
Okay, well, we'll start there then.
All right, thank you, John.
All right, Mr. Bernick, so let's start there.
Again, we're traveling under Brady, and he's asking for evidence, and our communications with the White House counsel's office was about logistics and procedures, whether they had a TUI type process in place.
Okay, so he's saying they're not entitled to any of this. They want access to this. They're using Brady to get it. They're saying that Brady entitles the defense to exculpatory information that might exonerate their defendant. In this case, it's Jeffrey Clark. But Brady is not applicable to everything. You don't get the government's entire case file. You just get the exculpatory stuff. So he's coming out and saying, well, it's not exculpatory at all. There's nothing in there. It's just logistics and procedure, and they're not entitled to that.
It wasn't about obtaining any type of evidence from them.
This seems a bit different. We're not talking so much about the logistics of witnesses as to whether there is potentially any coordination or political motivation that might.
Well, that's
Yeah, Judge is exactly right. Logistics for what? With the White House counsel, what are they logisticking with you?
It would be speculation right now because I think he concedes he doesn't have access to your emails. It would be unlikely unless he was sitting in the room or bugged it that he'd have any idea what was in there. But apparently he's got some documentation that a meeting did occur. And so
A meeting did occur from Nathan Wade's own billing records, which we got through Mike Roman's filing.
I guess the issue would be a selective prosecution claim can be brought pre-trial if they think that there are grounds on it. And that's a bit different than just asking about whether a witness is going to show up or is not going to show up, right?
In other words, the defense needs to know a little bit more about this White House counsel stuff, because if it looks like the White House is pressuring Fani's office to prosecute, then the Jeffrey Clark, the RICO, the Trump defense, all the defendants, they could file a motion for vindictive or selective prosecution saying, look, this is not actually legitimate. The White House is compelling, by being the White House and the feds, this district to bring this claim. But Trump's defense, Clark's defense, can't know about that unless they can see the documents. He says, well, it's kind of like other things. It's just logistics and procedures. And he wants to dig into that. Why is it just logistics and procedures about other witnesses, about who's going to show up to testify with the White House counsel?
The original question was, is there something actually in writing that shows communications between
Here it
the
comes.
office and the White House counsel?
Here it comes.
we did get a letter from the White House counsel's office.
All right,
It was
so-
about logistics and procedures as stated for.
All right, so it's just that you're saying the sole written communication, whether by text, whether by email, whether by written correspondence, solely consists of one written letter.
Written letter. Well, there's two written letters on it.
Well, actually, there's two, okay? So 2 written letters from the White House counsel. Yeah, actually, there is one. Oh, there's one? Oh, there's only one. Okay, so the only sole thing, did you see what the judge was trying to do? Trying to kind of clean that up a little bit? I actually like this judge so far. It's like, okay, so just one thing. Actually, there's 2.
And that's a bit different than just asking about whether a witness is going to show up or is not going to show up, right?
Correct.
So the original question was, is there something actually in writing that shows communications between the office and the White House counsel?
Yeah.
We did get a letter from the White House counsel's office.
All right,
It was
so
about logistics and procedures, as stated before.
all right, so it's just that
It
you're
was about logistics and procedures. What are they sending them questions about?
saying the sole written communication, whether by text, whether by email, whether by written correspondence, solely consists of one written letter.
Written letter, well, there's 2 written letters, Your Honor.
Ooh.
About procedures, about how we interviewed, whether it was a two-type process with former or current White House officials.
Okay, so it's about 2E type processes, which I'm guessing is about discovery rules in the state of Georgia, whatever their criminal code is. So the White House is asking them about their interviews, about who we interviewed, whether it was in compliance with these processes. Why would the White House even have questions? Okay, look, don't tell me that questions are not instructive. Here's the letter that I could hypothesize. Dear Fani's office and Nathan, hopefully you guys enjoyed your cruise together. Question for you. We are just asking about the logistics and procedures of your ongoing prosecution. Here are some of the questions we have about the logistics. Did you interview this person by this date? Well, that's a logistical thing. Or what was the schedule with this person? Has so-and-so actually interviewed with you yet? Because we might need to talk to him next, right? How about that one? Did you interview this person by this date? Because we're going to schedule this to interview him later. You go, oh, that's just logistics. It's a scheduling letter. And you're sitting there on the prosecution's team going, actually, no, I didn't even know who that person was. Who is that person? John Doe. Who is this person? No, never heard of him. So no, we're not interviewing him this week. So this logistically, you can schedule him later on. Whatever it is, right? Like you can communicate a message to somebody without communicating a message to somebody. We just have some questions about whether you're scheduled to interview this team of people. No, didn't even know they exist, but now I'm going to be. Thanks. And it looks like logistics and procedure when it's not at all.
Okay.
Can I?
Yeah, go ahead.
I mean, we're talking about selective enforcement here, and let's just go to what you need to prove with a selective enforcement action. I mean, in Georgia, for there to be a constitutional violation, selective enforcement must represent an intentional and purposeful discrimination, which is based upon
Hey, my man, we can't tell if there is something there yet to begin to make the claim. So he's jumping ahead to the next chapter. We're not there yet, brother. We have to talk about access to the documents so that we can determine whether we can bring a claim or not. He's saying, well, they can't even bring a claim. We don't even know if we can yet. That's the point.
deliberate, unjustifiable standards such as race, religion, or the arbitrary classification. Georgia also recognizes that just because there's a first time prosecuting someone under a statute, or there's the first time that someone might have been prosecuted under a statute that's been on the books for a long time, that does not give rise to a selective prosecution. And also, while we're talking here about his reasons for wanting these items, his reasons for wanting these items are inconsistent with each other. On one hand, he's talking about White House counsel's office, them aiding us and having a selective prosecution, them directing us towards a prosecution. On the other hand, we're talking about DOJ tampering us and not letting us prosecute the people that they told us to go prosecute. So his inconsistent theories are going at it. He's just trying to get any way under the sun. And just to recap, these are about logistics and procedure. This isn't evidence. This isn't anything that is obligated to be disclosed under Brady.
All right. So kind of a kitchen sink approach right there. He's just going down his bullet points, throwing a bunch of stuff out there. Most of that is in the next chapter. Like, we're not there yet. We want to talk about getting access to the document so we can decide whether there's a legitimate claim or not for selective prosecution or vindictive prosecution. Yeah, he's a little nervous up there at the podium.
Would you agree, though, that Brady doesn't necessarily have to be evidence that on its face is material, but something that could lead to material evidence?
Exactly. We want to investigate it.
So it just has to initiate that chain of discovery.
It could initiate the chain of discovery, but in the end, it has to be about evidence or what's coming out.
Sure. Okay.
Or
And so if this created some kind of lead, you would agree that a selective prosecution is a viable claim. There are a lot of hurdles, and I don't think that they've jumped any of them in this as alleged in this motion to compel.
Yeah,
I
we're
think
not
they have to
there
show
yet.
disparate treatment among other
Not
similarly
there yet.
situated potential
But we're working
defendants.
on it.
That hasn't even been alleged. But a selective prosecution is a real claim.
it is a defense that's viable in Georgia.
All right. And that's one that would have to come up before trial because a jury would never get to hear any of this.
There is case law that says it is a pretrial motion, yes.
All right. And so, Mr. McDougall, let me just emphasize that. This argument you're making about selective prosecution, would you agree that that is something that doesn't go to the merits of the case at all? That's not something a jury would ever hear or be able to consider?
Well, and part of my argument is the case has has no merit and he's being prosecuted because of politics. So the merits and the selective prosecution argument are,
Well done.
are joined. But I think I want to reserve the right to change my mind, but I think that's what you said is right, that it wouldn't go to the jury.
Okay. I mean, effectively, otherwise, you're arguing for nullification. Is that fair?
Yeah, which, you know.
I guess we'll address that if we get there.
Oh gosh, I can't even take it. That was so good. Okay, so you're not supposed to argue jury nullification to the jury. Oh my gosh, that was incredible. The judge says you can't argue jury nullification. If you do that, you're arguing jury nullification. And this guy just scoffs under his breath. He's like, well, yeah, basically. And he just told it right to the judge. Now, you're not supposed to do that. Like, you can't argue jury nullification to a jury. That's out of form. That's out of order. Like, the jury's there. They have to follow the law. And he just smokes him. He's like, well, we're going to argue it to the jury. Yeah. And he's like, okay, we'll deal with it when we get there, the judge. Amazing.
I guess we'll address that if we get there.
Port in a storm, Your Honor.
What I'm getting at is,
Oh my gosh.
also coming back to the original point, which is the timing of Brady. You know, it's usually supposed to be at trial. However, there's the caveat, unless earlier disclosure would have impaired the defense, right? We're kind of in the situation where this is a pretrial motion that they have to make. And by the time you get to trial, perhaps it's too late to even make it. So
Any port in a storm is the phrase. Excellent. Really good. And I like he's just being candid about it. It's really funny to tell he's like, well, you can't argue jury nullification. He's like, well, I'm kind of going to do it anyways. I can't even take it. So funny.
point being is in situations where the materiality is even somewhat up to debate, I think the proper procedure is an in-camera review. And if you're saying there are two letters that exist, it seems that those could very easily be submitted under seal. We can see if there's anything in there even remotely resembling something talking about political prosecution or selective prosecution that would further the investigation of that.
Now, I want to be very careful here on that, right? Like, the letter is clearly not going to say that there is, it's not going to be Joe Biden says prosecute Trump, signed White House counsel. Like, we're not expecting that at all. What this judge just said is, I think it makes a lot of sense to review those two letters in camera, meaning at the judge's chambers, private, off the record, when they're filed under seal. In other words, let me look at them, then I'll decide what to do about them. But the standard, I hope the judge looks at them. I would like to see them. I don't know what's so complicated about it. If they're benign, why don't we all just see them? Like, let us see what the White House said about all this stuff. But it's something he'll take a look at under seal. And again, it's not going to be like a big red Sharpie that says, prosecute Trump. It's going to be something else that probably looks a lot like logistics and procedures. Hey, we just have a question, or just so you know, we're doing this thing or whatever. But it's secret dog whistles about this is where you should go, right? It's conversations about the case. White House should have stayed far away from it all. And the judge is going to look at it sounds like.
And if so, then that resolves this motion to compel. Any reactions to that, Mr. Burnick?
I think it doesn't allow them to root around in our files, which is not required under Brady, and that is the remedy for a plausible claim under Brady, is to do an in-camera inspection.
All right. Anything else then you think would be relevant to this issue?
No, Your Honor.
Mr. McDougal?
Just a couple points, Your Honor.
Sure.
So I learned something I didn't know, which is that there are letters. The second meeting in November doesn't say it's with White House counsel. It says DC White House. So maybe it was with the White House counsel's office, but you can't tell it from the time entry.
Yeah, and so maybe that's not. Maybe that's actually with Washington, D.C. with political people. Like, is it just lawyers, or are there other political operatives in the room? Is it White House counsel plus Karine or, whomever? Who is it?
The way Mr. Burnick described it is a TUI-like set of considerations at the White House. The White House does not have TUI regulations, okay? So what considerations would there be?
So 2E regulations, again, Georgia rules. And so he's saying, no, we're talking about 2E and all these different things.
It would have to be executive privilege. It would have to be. So their position on executive privilege, if it's articulated in that correspondence, is something that we know what their position is with respect to congressional committees, with respect to the criminal prosecution, but this is a state prosecution.
I think we're going back to
The government and these privileges are much, much different in this form than they are in those forms.
Well, let me make sure I'm clear here, though. The original motion to compel, the request is copies of all communication with White House counsel's office, right?
Yeah, I think I did say that.
And so that's relevant solely as it relates to building a claim for selective prosecution?
Well, I've learned something that I didn't know, Your Honor.
Okay.
In this hearing, which is that the letter is a TUI-like dialogue. And I think we ought to get that too for all the reasons I gave as to the other TUI correspondence. And the TUI correspondence is not just with DOJ. There are other federal agencies that have former employees with knowledge relevant to this case who are on the state's witness list.
Nice.
Like the former head of CISA, Cyber Infrastructure Security Agency, people like that. And we might want to put up the former director of the Office of National Intelligence, Mr. John Ratcliffe.
That actually reminds me of a point I meant to ask you on part one. Were you saying that you were needing the testimony of Rosen and Donahue because you believed that would help your defense?
No, I'm sorry, Your Honor, if I wasn't clear. From what we know, their video testimony was presented to the special purpose.
You would be fine if they didn't show up in court, is what you're telling me.
I'd be thrilled if they didn't show up.
Amazing.
All right, I just want to make that
I don't
clear.
think I would have to show up either.
This attorney is great.
Okay. All right. I understand the point you're making on TUI. I'm still struggling.
I'd love it if the witnesses don't show up because my case is going to be dismissed. They need those witnesses to make their point. If they're not here, I win.
To see how that fits into Brady, but I'll take a look at the case law and we'll see.
I know it's not binding on the court, but we did cite to a section of the Justice Manual that exculpatory information should be provided so that it's useful in time for motions. That's consistent with the underlying doctrinal purpose of affording the defendant due process. I mean, do we have to wait until after the conclusion of the state's case to know that they can't prove it if we know that these guys can't testify? I certainly hope not.
Mr. Byrne, do you want to speak to that at all? Or even talking about a material issue, can the state prove its case without Rosen and Donahue?
I mean, we're under, prosecutor ethics to continually review our case as we get witnesses and evidence and different facts come up. And so if we couldn't prove our case, we have to be able to review them. Might have to dismiss it. It happens all the time in other prosecutions and happens in this courthouse that we can't prove something, we null process. So
you null process, yeah. Or you grant diversion deals, right? So that you don't have to admit that. You don't have to get a dismissal. Sidney Powell threatened Jenna Ellis with a bunch of jail. Then when you realize your case is crap, turn around, give them diversion deals that are going to result in all of their charges being dismissed, their records being sealed. They were not charged or convicted of anything. No convictions at all will be on their record after the thing is concluded. So yeah, it does happen. Generally not in a nationally renowned RICO case. You dismiss other cases like when the victim doesn't show up, but this is a national case with all these co-defendants. They're just going to dismiss Jeffrey Clark's prosecution?
as it comes through, we'll continue to abide by our ethical
They have nothing,
obligations.
Your Honor, by indicting Mr. Clark, they have represented to the court and to us
At the time of indictment.
and the world that they can prove the case.
Yep.
And they may have a letter that tells them they can't.
Now they're hemming and hawing about it.
And if that's true, that's important.
They're jerking us around in court today.
As I understand it, that letter was saying potentially that they couldn't testify before the special grand jury. And I guess there's a question of whether they might have another letter at some point in the future indicating whether that's going to be the case for trial. So the argument evolves, right?
So maybe the witnesses that the government needs to prove Jeffrey Clark's case, remember there's a bunch of different charges for different components of the conspiracy. The RICO conspiracy, like Sidney Powell was involved in like hiring an expert witness to go investigate stuff. The list goes on, right? All these different little chapters of this much broader book. And now they're saying you don't have your witnesses in my case. Those two witnesses are not going to testify, presumably, is what he's excited about. But also they were colluding with the White House.
And just to clarify on this letter with the DOJ, we're not getting into the substance of it, whether it was a denial of grant, because that gets into the substance of what's going on.
Okay, so the DOJ sent some other letters and they may be saying, well, these guys can't talk.
Just that it's generally about TUI processes.
Sure. All right. Well, I guess as indicated, I'll take a second pass at how these two requests might fit into Brady. And as to the second issue, we'll start just with the in-camera review, seal the documents, any correspondence with White House counsel's office, as that's what was requested in the motion to compel.
Granted.
And why don't we start there? If you can have that to me, if you can compile it. And then after I've had a chance to review it, then I'll make the findings, whatever I need to make in the written order addressing all of these issues.
And Your Honor, if I may be so bold as to suggest an in-camera review of any TUI correspondence with the other agencies as well.
Well, let me see where Brady falls in that, where it falls first. I think that I'm stuck more
there.
on the legal issues there.
Good for him.
All right.
All right, Judge.
And we'll go from there. Anything else then on this motion to compel?
No, but I
Otherwise-
we might approach the bench to discuss the motion that I filed earlier this week with a request to file under seal.
Sure, that's fine. We can do that. Before we do that, we can wrap it up though if there's nothing else.
Well, when do you want the correspondence to you following your seal?
Now, 5 o'clock
I
tonight.
mean, how long do you think it'll take you to compile it? If it's 2 pieces of paper,
Those 2 pieces of paper, but if you wanted to, yeah, it shouldn't take that long.
I'll be here tomorrow too.
Okay.
And I think
Now,
you can just do that, a
bring 'em
physical
up.
copy in an envelope. And let's say COB
Do you
by
have copies in your file right now? Bring it up here, my friend.
the end of the week. All right. Okay. If there's nothing else, then we'll be off the record.
All right, thank you.
Oh man, so that was a lot of fun. And this attorney McDonough is outstanding. I absolutely love his candor. Well, that's jury nullification. Yeah, I know. What's your point? Any port in a storm, my friend. We're doing it. I love it. All right, so what we see here is a nice little victory here for the defense. So those 2 letters are now going to be ordered to be disclosed, have been ordered to be disclosed, over to the judge under seal. So we're not going to see them. He says there's only 2 pages. That's it. We'll see if they're anything longer than that. You know, White House is usually a little bit more verbose, but judge will take a look at it. And what I also love about this, man, is he also submitted another filing, or he actually submitted permission to submit another filing under seal. So he might have some more major bombshells that he's going to drop any minute. And so the gears of justice continue to come off the rails there in Fulton County as their prosecution continually proves their prosecutors are incompetent largely. But now let's get some reaction from this guy. Mike Collins is a representative out of Georgia. Here's what he said about this. He says that Georgia state representatives are now moving to impeach Big Fani, the biggest Fani in Fulton. Says they should use their ability and their rights to impeach this lady and get her off their case. So this is a Georgia state representative who's commenting on local Georgia stuff. You can see there's Fani, there's Wade, these two little alleged lovebirds walking around. Here's what he says.
Nathan Wade, but now there's some more going on.
Yeah, this investigation happening with this committee that was formed. A Georgia state representative is moving to impeach her. Here to weigh in is Georgia Congressman Mike Collins. Congressman, good to see you. Thanks so much for coming on. This Senate investigation, the state Senate investigation, I want to be very clear that, again, this is still a local case, a local investigation. This has been approved to move forward. What do you see coming out of it?
Well, you know, I think the wheels are clearly falling off the bus on this investigation. I was telling a group earlier this morning that I think this was more made for a Jerry Springer episode than it is anything. When you've got Fani Willis, who's obviously got her eye on somebody else's Fanny, instead of actually out there trying to do the people's work and try and, you know, pay for it off the taxpayers' dime.
You know, sir, this case has now got national attention because a lot of people are wondering what is going on in Fulton County. The fact that all of this is going on behind the scenes, and yet the former president is facing some serious state charges here. Of course, I'm referring to Donald Trump and then those other co-defendants in the case. Republican Georgia State Rep Charlize Byrd officially filing a resolution to impeach the DA, posting this to X, saying, with freedom on the line, bold action is necessary. It's time for the legislature to do its constitutional duty and hold corrupt Fulton DA Fani Willis accountable, which is why she's introduced the articles of impeachment against Willis. Congressman Collins, do you think this happens here? Would there be support?
Yeah, you know, I think it should. I think it's evident. And I think as more and more evidence comes out, especially over in the divorce court that's going on between Wade and his soon-to-be ex-wife.
Jocelyn.
That's where a lot of your evidence has been coming from as to where the money has been funneled between, so Wade and Fani Willis can go on their escapades and their trips. The state legislature has the ability. They should take that up and they should use their ability and their rights to impeach.
All right, so they're talking about some other things, but obviously Fani is focused on her RICO charges and her RICO case. So very good proceeding there in Judge Scott McAfee's courtroom. We're excited to see if those letters are ultimately released or unsealed so we can see what this collusion looks like. And again, even if the letters don't have a paint by number prosecution, you know, schedule, prosecute this and do this, it's still conversations. And I'm very curious what is inside. So we're going to be here continuing to cover the Georgia case, all of the Trump prosecutions, wherever they're happening, New York, Florida, DC, Georgia, anywhere else they decide to come after him. We'll be here to cover it. So my friends, thank you for joining and subscribing to our channel, wherever it is you're watching this. Don't forget to check out robertgovea.com. The link is down in the description below. All of our PDFs are there. We have our store, which is available. You can grab a hat, grab some gear, and look good while you're supporting the show. And we'll look forward to seeing you back here on the next one.